Hello, everyone, and welcome back to Beyond the Evidence, the podcast where we dive deep into true crime cases, uncovering the facts and exploring the unanswered questions that keep us coming back for more. I'm your host, Marv, and I want to thank you for joining me today. If you haven't already, please subscribe to my YouTube channel and hit the notification bell so you never miss an update. And if you'd like to support the channel, you can find links to my PayPal and Cash App in the description. Now, let's get into today's topic.
Breaking all the patterns, facts and theories, clues and controversy. Join the journey, uncovering the mystery. This is Beyond the Evidence, where justice prevails, with Marv leading the way. Truth never fails. Now get ready for this live stream. Super chat, highlight your message. Don't fall victim to the irrelevance. Hit that like, share, subscribe to Marv's Beyond the Evidence.
Hi everyone, how are you doing? I'm sorry I didn't get back online yesterday. Things were a little hectic here. But today we're going to read through a lot of this. People are asking me, Marv, why are you reading the transcripts from the Delphi trial? Do you know how long that's going to take? Yes, I'm well aware. I think it's important that somebody actually goes and takes the time to read through each hearing and then the testimony from the trial, because not everybody can go and read all those documents. There's a lot of them. There's thousands of pages here. Okay. So a lot of people like to just listen to somebody else read it. That's why I'm taking the time to do it. Other people, they want to see the documents for themselves. And that's fine. I'm going to try to put them out there so that those that actually want to read them can read them. Hey, Mustang girl, how you doing? Silas says, hi, lovely. I really appreciate you reading them. Absolutely. So however long it takes to do this, this is what we're going to do. I am going to do these in individual live streams because some people may want to hear one person's testimony and not everything. So I'm doing the hearing, and this is the third part because it's so long. Then I'm going to set up a live stream and do both of the openings. And then I'm going to set up individual live streams for the individual testimony, unless it's only like 5 or 10 minutes. Then I might do a couple together. But yesterday we left off. Why did they move RA? Okay, let's get into this. Richard Allen has been requesting to go into general population. Okay. We all know that if he is put into general population in an Indiana prison, he could severely or fatally get injured. Okay. So, in a lot of these cases, they move these individuals to different states. Less people in the prison know about the case, about the individual. Okay? And it is Indiana's way of protecting themselves, the DOC themselves, the prisons themselves. If something were to happen and Richard Allen was to get seriously injured or even become deceased, that prison could be held responsible. That is what I think is the reason he was moved to Oklahoma. Look at Chris Watts and what he did to his family. They actually moved him to Wisconsin, where he has been beat up a few times, but nothing fatally, nothing severely. So I hope, Karen, that helps answer your question. You're welcome, Spooky. I'm honored to do it, and I'm happy to do it. Let's see. Thank you. I'll be Frank for Gibbo for being here, and Karen and Mustang. When Oklahoma prisons find out what he did, won't be safer there either. True, and we all know that prison guards let things slip as to what you're in there for. But I still think he's got a better shot of remaining alive in another state. So I think that is one of the number one reasons why they have transferred him. And like I said, the second, they don't want to be responsible. None of the Indiana prisons want to be responsible if something does happen to them. So, yesterday we were talking about, in the hearing on October 17th, the defense wanted to exclude testimony from officers, inmates, things like that, that had stayed and observed Richard Allen in prison. And so we went through the defense's initial argument. Then the prosecution got their say in the matter. And now we're going to start with Mr. Rossi wants to address the judge once again in his argument. So we're going to continue with that. But before we do, I just want to say welcome to everybody coming in. Kiwi, nice to see you. Silas, Mustang, Gibbo, glad y'all could be here. Those that are watching and are not chatting, thank you for being here. And even those that are going to watch the replay, appreciate it. Oh, Kiwi, ignore the Nightbot. It's because you put the clappy hands multiple times. Don't worry about it. If you want to do it multiple times, go ahead. Okay. So let's get started here on Mr. Rossi's second go-round here. So, Mr. Rossi, Judge, I would just respond by saying this. The reason why they're going to bring every one of these people in is because they're going to want the jury to hear that he said something incriminating in front of that person. That's the whole purpose for bringing them. And so the idea that by extension you can say, oh, do you think he was faking it or telling the truth, is asking that witness to conclude his guilt or innocence. So I'm going to stop there. As we heard yesterday, this is the main focus from the defense. They want to know they want to stop these people from saying if they think Richard Allen was faking or not. And so, those two things are married together. You cannot separate them in this case, or they wouldn't be marching these people in. And so it does violate Rule 704, and the court should, really think about that. The idea that somebody, let's just use an example, that guard number 1, comes in and says, Rick Allen told me that, he ushered those girls down the hill and he got scared and he killed them. Well, do you think that he was faking it when he told you that? Or do you think that he was being genuine? That in and of itself cannot be separated from the statement. An opinion about that guard, about his mental state at that time, cannot be separated from the statement that he just was alleged to have made. And so it is a direct violation of Rule 704. And I'd ask the court to take that into consideration. I would also point out this. The Department of Corrections has a team of mental health representatives that are assigned to each of these inmates. Specifically, in this case, Mr. Allen. There's going to be doctors. Dr. Walla, you've already heard from her. Dr. Martin is the second one who is on the state's witness list, who is a psychiatrist, who signed a bunch of orders to have him injected with Haldol. Hang on, I just lost my place. Why did it do this to me? Okay. I know why. Gotta fix it. Okay. All right, so I'm going to repeat that. There's going to be doctors. Dr. Walla, you've already heard from her. Dr. Martin is the second one who is on the state's witness list, who is a psychiatrist who signed a bunch of orders to have him injected with Haldol and other things. There are mental health workers at the prison. All of these people can come in and the state can attempt to establish foundations for them to testify about things that go to the state of mind. But in this particular case, they're trying to do it through inmates and guards. And we, of course, believe that's inappropriate. Thank you. Okay, wait a minute. Nightbot does not have access to time anyone out. All right. So then the court. Anything else, Mr. McClelland? Mr. McClelland, Judge, that's wrong. That's not what the state is using this information for. We're not going to have the guards go up there to testify about the truthfulness of his statements. That's not the intent. They're going to testify about his behavior and whether his behavior was genuine or not based on their training and experience. The opinion of experts is not the only opinion that's admissible in court. We have these rules because lay opinion and skilled witness opinion is admissible. They're not going to testify about the veracity of his statements. They're going to testify about his behavior and whether or not they thought he was faking it or not. These are people that are able to observe Richard Allen 24 hours a day, that stand in front of his cell, that are with him on a daily basis. And so their opinion is valuable to the jury to understand, as opposed to an expert who's only interviewed Richard Allen once or twice, or interviews him once or twice a week. These people are around Richard Allen every day. And so we do believe, the state does believe it's admissible. Judge, and that's all. Nothing else, Judge. The court. Okay. Well, I mean, based on the argument, the witnesses, unnamed witnesses, but the folks that you've mentioned here in the motion, the various prison guards, inmates, law enforcement officers, and other potential DOC staff members, they can clearly testify about their observations of the defendant and his behavior. They can testify about what he said. They can testify about what he was doing when he said it. They cannot testify as to whether or not they believe he's guilty or he's innocent. So that's clearly inappropriate. That's not for them to determine. That's for the jury to decide. And if the state can lay a foundation based on their experience and observations and amount of time that they've spent with him over a period of time, they can testify about their perceptions of Mr. Allen as a skilled witness. I'd have to hear more from the specific witnesses about whether or not they can testify as to whether they believe it was genuine or not. And by genuine, I mean the statements, if the statements and what their observations of his behavior, if that is genuine. So that's up in the air, because that depends on the foundation that you can lay with those particular individuals. But they can clearly testify about the observations of him and about his behavior and about what he said and what he was doing, but not on his ultimate guilt or innocence. That is not for them to determine. That leaves us then with the defense, state's motion in limine regarding the IPASS settlement. Okay, so what she's saying here is that when it comes to whether they feel Richard Allen was faking or whether he was genuine, the defense is going to have to object during the testimony on any of this. And she will have to make a decision then based on what the prosecution lays down as foundation. Okay. So then they're going to get into the next one, which is the defense or the state's motion in limine regarding the IPASS settlement. Mr. McClellan, Ms. Diener will be arguing that one, Judge. The court. Okay. Mr. McClellan. And then Mr. Luttrell will be arguing the one on Mr. Tobin. The court. Okay. Mr. McClellan. Thank you, Judge. The court. Ms. Diener. Ms. Diener. Thank you, Judge. With regard to IPASS, this motion is filed based on past experience in the 3 days of motions that we heard in Carroll County. IPASS was used to some extent with some of those witnesses, especially Dr. Walla. And it was also used in some depositions of witnesses that the defense added in a filing on October 12th, which we've not addressed yet. But the IPASS settlement is a completely separate lawsuit involving DOC. The state believes it has no relevance in this case. Mr. Allen entered the DOC in November of 2022. I tried to do some research about whether the IPASS case has been dismissed. As it was indicated, it would be in the settlement agreement. I know there are some extensions that it could go beyond another case, Mast versus Indiana Department of Corrections, which I cited in my motions. But in the event that it did exist or extend related to that, it was to be 1 year after that case was closed, and that one has been closed. So from everything that I can find, the settle agreement is no longer in place. Even if it is, the IPASS settlement is about DOC policy, and the witnesses that it was being used to question and cross-examine thus far was a witness who doesn't have any authority to respond or participate in the reaction of DOC to what IPASS and the settlement was focused upon. So the state is asking that the court exclude that from questioning, testimony, exhibits with regard to a witness that does not have any responsibility as an employee of DOC or as a legal representative of DOC to deal with that issue. The policies of DOC are the policies of DOC. And if a person is an employee, like Dr. Walla was, of Centurion, providing a service to DOC inmates, it is not her place to participate in necessarily. And she didn't indicate that that was her responsibility. With DOC policy as it relates, and it's just a muddying of the water, it's confusing, and it, I believe, is intended to cast aspirations on DOC for the benefit of establishing that Mr. Allen made certain statements due to his environment, but the state believes that would be an inappropriate use of this outside litigation with witnesses that have no place in it. So we would ask for any reference to IPASS, unless there's a separate foundation established, that it be excluded from the proceedings. I'm just checking out comments here. Okay, the court. Mr. Rozzi? Mr. Rozzi, thank you, Judge. So the IPASS settlement was offered up in the exhibit list at the pretrial hearing. So I'm asking the court to take judicial notice of that document. The court, I will. Mr. Rozzi, at that time, I appreciate that. The court, yes. Mr. Rozzi, a couple of things here. The relevance of the IPASS settlement is that it includes a lengthy definition of the phrase serious mental illness. And that particular phrase is one that is relevant to this case because it's the defense's contention that when Richard Allen hit the doorsteps of the DOC in November of 2022, that he had a serious mental illness. Remember that. The defense is stating that as soon as Richard Allen was arrested, he already had a severe mental illness. And because one has a serious mental illness, they are afforded certain rights in the DOC, and frankly, in the county jails from one side of the state to the other, because the county jails have adopted the same standards as the DOC as it relates to solitary confinement. And so that definition of serious mental illness affords him those rights, which then means that the DOC has to treat him in a certain way as it relates to his confinement. And so the IPASS settlement is the seed, essentially, from which that definition, which was broadened, frankly, to include the very disorder that Mr. Allen had, which is a major depressive disorder, when he hit the cell block, but that is the seed that essentially created what now is the existing DOC policy. And so that's the relevance of the IPASS settlement. There are a lot of things in the IPASS settlement, with all due respect, that that don't have. There are things in the IPASS settlement that don't have anything to do with this particular case. Naturally, there may be some facts in there about things that just aren't related to this case, like about other cases and the circumstances that were created with the plaintiffs who existed. But the definition of serious mental illness and those privileges and rights afforded to inmates that have those are part of that settlement, which was then, that information was then taken and essentially rubber stamped into DOC policy, which will also be an issue in this case, and I've offered up some of that to the court previously in the July hearings. And so that's the reason why we think it's relevant. And that's the reason why we think we ought to be able to educate the jury about how you treat offenders, inmates, in this case, a pretrial detainee in a solitary setting, and what types of mental health services that should be afforded to them. All of which, of course, would be relevant to his state of mind, the credibility of the things that they claim that he said that they were incriminating. Even now, those actions that these guards apparently, these guards can come in and testify about, well, he was genuine about this, or he was, he was faking it, or he wasn't. All of those things are relevant and connected with the way he was being treated at the DOC in terms of his solitary confinement and how he was handled. So those are the reasons why we're asking to be able to put the IPASS agreement in. If there's, to the extent we need to redact some of the factual information in that agreement that pertains to the plaintiffs in that case and their circumstances, that's understandable to me. But the definition of serious mental illness, I think, stems from that agreement and has been carried on. And frankly, you'll hear testimony from DOC officials, a couple of which were deposed just recently, that acknowledge that settlement agreement, the significance of the settlement agreement as it relates to the DOC's current policies, and the fact that the definition of SMI is consistent with what's in the settlement agreement. And in fact, in some of the DOC policies, I don't have the policy numbers fresh in my head. I think one was 2.22, but we offered 3 of those up, I believe, at the pretrial hearings. In one of those policies, there's actually a reference to the IPASS settlement. So from that standpoint, we think it's relevant and it will help tell the whole story about the timing of how all this came about. And so we'd ask the court to consider that. Thank you. The court. Anything else, Ms. Diener? Ms. Diener, Judge, by his own admission, he says the DOC policy already contains the definition of serious mental illness, which is actually broader than what is referenced in the IPASS statement. Again, how is the IPASS settlement helpful or relevant? It's confusing. It's a distraction. It's another litigation. Mr. Allen came in at a time when the policy had already been modified as a result of IPASS. So therefore, the change did not happen while he was there. It has no impact on how he was being handled or treated. The state's not objecting to DOC policy being referenced that was in place at the time that Mr. Allen was there. Outside of that, again, not relevant and confusing. We're asking the jury to take on a lot of information, and I ask the court to find that those are not relevant. In addition, there are additional rules that of evidence that speak to the use of documents from litigation outside of the case at hand. I cited those in the motion. I think those are also something to be considered by the court when talking about relevance, and the state would have nothing further. The court. Well, if the purpose of the settlement agreement is to educate the jury on how you treat an inmate in a mental health setting as it relates to the state of mind, does DOC policy already incorporate that? Mr. Razi, it does, in part, Judge. The court. Okay. Mr. Razi, may I continue? The court. Yes, yes. Mr. Razi. Okay. The court. Mr. Razi, the concern I have is that the jury might view the DOC policy as having been created on a certain date, whatever that date is on the policy, and then everything from that point forward is all new, and it's subject to, hey, the policy was created in 2022, and so we're just learning, we're working under the policy in its infancy stages, when in fact there's a long history of where this policy came from. That lawsuit was the IPASS settlement, was like 2012 lawsuit. And I can't remember exactly while I'm standing here. I'm not great with dates in some respects. I want to say 2016 was the date of the court order that Judge Pratt in the Southern District issued the court order finding the DOC, Indiana Department of Corrections, responsible for violating the rules as it relates to. Well, they found them responsible for violating the Constitution as it relates to cruel and unusual punishment of offenders in the DOC. And so there's a whole story of how we get there. And I think that the jury should be able to know that this isn't a matter of first impression for the DOC. This is something they've been dealing with a long time, and they can't get it right. So that's why I'm asking to show them the whole story. Thank you. Mustang, you bring up a great point. He was in protective custody, not solitary confinement. But as you're going to see as we read through all of this, the defense is steadily, consistently going to use the words solitary confinement. And you're right. That is completely different than protective custody because they pretty much take everything away from you. So the court says, well, I understand the argument and I appreciate the argument, but the settlement IPASS settlement agreement is not relevant to the issue at hand as to whether or not Mr. Allen did what the state alleges that it is alleging. I mean, if you can educate the jury within the policy and confines of the DOC, then that's in the policy and you can do that. But admitting the IPASS settlement with the lawsuit that ended in July of 2020, when he didn't get into the DOC until November of 2022, is not relevant. It's inadmissible under a bunch of different, particularly just the whole litigation. There's no need to have all of that litigation inserted into the criminal matter. So you can do it other ways. Now listen to this. Okay. She's giving them options. Even though she's saying, no, you cannot use this, she's giving them options. Okay. So you can do it other ways, and I would allow you to do it in other ways other than, getting in the entire settlement. If the DOC policy that was in place at the time Mr. Allen was in there defines the serious mental illness, then it defines serious mental illness and how the DOC should be treating folks with that condition. So I'll grant the state's motion in limine regarding the IPASS settlement. Mr. Rozzi, may I ask for a point of clarification? The court, you may. Mr. Rozzi, Judge, just to make sure, you're only prohibiting us from putting the actual document in, right? We can make a reference to settlement, which is the court. Well, the document and reference about a lawsuit, there's no need to reference a lawsuit if it's in the policy now that you can explore. Mr. Rozzi, but that is the policy references the IPASS settlement. It literally references it in the court. Well, there's no need to reference the policy settlement language. If the issue that you keep harping about is the educating the jury on how you treat an inmate in a mental health setting as it relates to his state of mind, and that he had a lengthy history or a definition of serious mental illness, you can focus on that without getting into anything about the IPASS settlement, without anything about the lawsuit, because it's contained within the policy of the Department of Corrections, according to both of you arguing. Mr. Rozzi, but you're not going to require me to redact that from the policy, right? The court, why do you need to do anything with the policy other than what I just said, which is, Mr. Rozzi, because I need to tell the jury the truth. I need to educate them about the truth. The court. Okay, Mr. Rozzi, and that is part of the history of that policy. Didn't just the court. You don't need the history of the policy. You've got the policy. Mr. Rozzi, thank you. The court, you're welcome. That leaves us with the state's motion in limine regarding defense witness, and I understand, Mr. Luttrell, you'll be arguing that. Mr. Luttrell, yes, Your Honor, thank you. The court, and the defendant filed a response to that motion on October 7th. Mr. Luttrell, yes, Your Honor. The issue is not whether Mr. Tobin is an expert, but what is his area of expertise? And is that an area of expertise relevant, and is it helpful to the jury? Mr. Tobin is a metallurgist with a bachelor's degree in metallurgy and 27 years with the FBI as a metallurgist. He is an expert metallurgist. He is not a firearms expert. He has never conducted a firearms identification exam. He has never been trained in firearms identification. It was some years ago, but to my knowledge, this hasn't changed. I believe 8 years ago, he was asked in court if he had ever been trained in firearms identification. No, it would not be worth my time. In a deposition 8 years ago, and I don't believe it's changed, he testified that he has never conducted research on firearms identification. What he has done is he has he has researched research. So he has researched other people's research. Okay. Mr. Tobin said in his deposition in this case that he could opine on the flawed methodology of the state's witness, in fact, the flawed methodology of all firearms experts. The court ruled that the state's firearm exam testimony is relevant and probative. The probative value is not outweighed by an undue prejudice. Therefore, Mr. Tobin's testimony is not relevant, and it would not be helpful to the jury. He would be opining not that the state's expert got it wrong, or is mistaken, or failed to conduct a proper exam, or could have done a better exam, or documented a better exam if she had done this or that. He would be testifying that she cannot even conduct a firearms identification, and no other examiner could as well. Helpfulness, Your Honor, in the touchstone of admissibility under Rule 702, Whedon versus State 900 N.E.2D 2009 is a reference for that. It's not a case that dealt directly with, it didn't deal with firearms, but it dealt with expertise. If the topic of the expert's testimony does not address a fact in issue, the evidence should be excluded. Irrelevant evidence cannot assist the trier of fact. That's what I believe it was the Indiana Supreme Court said in Ross 516 N.E.2D 61. It's a far different case, a far different set of issues, but it was an area where a APE, add an R in front of it, trauma expert, was prepared to testify what type of apist the defendant was. The APE trauma expert had experienced and had the expertise to answer the questions, but that question was not an issue the jury was to deal with. It's the same type of analysis. The issues Mr. Tobin would address are not issues that would be helpful to the jury. An expert who qualifies as an expert to some matters can state an opinion on a matter, cannot state an opinion on a matter as to which the witness has no special knowledge. That's the Weishaupt case. If I pronounced it correctly, 26N.E.3D, page 3-3, page, I believe it's page 10, is where that reference is from, indicating that you may be an expert and you're qualified to testify to some things, but not to matters in which you have no special knowledge. In Turner versus State, 2011, Indiana Supreme Court case, which established, addressed the very question of firearms identification testimony. Turner is found at 953 N.E.2D 1039. The proponent of the expert testimony bears the burden of establishing reliability of the scientific principles upon which the testimony is based. We believe that under the law and under a definition of, in looking at both 702 and 403, Mr. Tobin would not be helpful to the jury, and it would lead to confusion, and he's testifying in an area in which he is not an expert. He has testified, as Mr. Rossi has pointed out in his pleading many times around the country, primarily in Daubert or free type hearings. I don't think I know he has testified in jury trials, but I think that's fairly rarely. It's primarily to testify to the threshold issue. Is this evidence admissible? It would be confusing to the jury if he were to testify, Your Honor, on the question that all these firearm examiners are junk scientists, which is a phrase that he has used in the past. There are 4 individuals listed, combined by both sides as addressing the issue of firearms in this case. 2 from the state, 2 from the defense. 3 followed the AFTE theory of identification, at least in large part, and are parts of a traditional AFTE firearms identification process. One of those 4 is different than the others, and I believe that Mr. Tobin's testimony would not be helpful because he is just not an expert in this area. Thank you. Please remember, in the chat, everybody has a right to their opinion. I'm asking you to be adults and to disagree in a polite way. Do not attack each other, anything like that. I see that it's going pretty well so far, but let's keep it that way. Okay, do it respectfully. All right. The court, Mr. Rozzi. Mr. Rozzi, thank you, Judge. As it relates to Tobin's expertise, I'm going to tender to the court Defendant's Exhibit A. May I approach? Defendant's Exhibit D offered. The court, you may. D, we're up to D. Mr. Rozzi, sorry about that. The court, and it is what? Mr. Rozzi, I'm sorry. The court, it is what? Mr. Rozzi, Defendant's Exhibit D, and this is a copy of Mr. Tobin's. The court, okay. Any objections? Mr. Luttrell, no objections, Your Honor. The court, all right. Without objection, D is admitted. Defendant's Exhibit D admitted. Mr. Rozzi, Judge, you're not holding the CV yet, so I'll wait until that happens. Then I'll talk about that just briefly. Does the court have the exhibits? The court, yes, I do. Mr. Rozzi, thank you. So with regard to Mr. Tobin's CV, this is his resume, you guys. I'd first direct your attention to the education there at the top of the CV, which indicates that he has a Bachelor's of Science in Metallurgy, a Master of Arts in Special Studies. In graduate studies, he has Material Science and Engineering from the University of Virginia. It is true that he has a background in metallurgy. Metallurgy is the study of physical and chemical properties and how they combine with each other and how they react to each other. It is a sub-discipline of tool mark identification. It's really kind of one of the foundations of tool mark identification. Firearms identification is also a sub-discipline of tool mark identification. So I have a sense that this court has probably been through this academic exercise before. But because I haven't been here and been a part of that, I'm going to try and explain this the best I can. I think the way to think about this discipline and these sciences, and however you want to define them, is to think of tool mark identification, kind of at the top and then underneath that. There are many sub-disciplines that are all kind of interconnected. It's kind of like a network of sub-disciplines. Metallurgy and firearms identification are 2 of those. Mr. Tobin has an extensive history in working in the field of metallurgy. Most importantly, and most specifically from a relevant standpoint, I would direct your attention to the professional experience that's at the bottom of the first page of Exhibit D. And what you'll see in there is that Mr. Tobin worked with the Federal Bureau of Investigations as a supervisory special agent. He was the manager of forensic metallurgy operations with the FBI laboratory, and his testimony foundationally would be that he worked for the FBI for 27 years, and he worked as an expert in their laboratory for 24 of those 27 years, dealing with toolmark, the trade of toolmark identification, and with his specific background in metallurgy. So in terms of his skill set, those things I think are noteworthy to the court. Obviously, the CV is quite lengthy. You can see that he's published in many different areas. I'm not going to belabor the court by going through all of those, but here's what I would say. I actually called Mr. Tobin back recently because I had cited in the motion that he had participated or testified, I think, in over 200 times in court settings. It turns out that he updated that. I was trying to be really conservative, but he said it's 309 as the last couple weeks, 46 states. He would testify foundationally if he were allowed to testify in this case. That's been in the District of Columbia, Puerto Rico, and he's also provided congressional testimony regarding issues related to firearms identification practice. Maybe most importantly in terms of his background and his skill set is the fact that he has participated and contribute is probably a better word, to decisions that have been made as it relates to the reliability of firearms identification, the discipline of firearms identification, and even most recently, in the case of Supreme Court of Maryland versus Aberquash, and that citation is 483 Maryland 637. That's a 2023 case, so it's 483 MD. 637 2023 case from the state of Maryland. And this opinion was issued in June of 2023. And essentially what happened in that case is it was a murder case and there were some bullets that were recovered. And it's kind of more of a traditional circumstance where the state offered up the bullet fragments from the projectile, and basically their expert came in and said, their firearms identification expert came in and said, those bullets were shot from that gun. Kind of the most traditional form of testimony in these types of firearms identification cases, or the most common. Of course, Mr. Aberquaw was convicted. That case went up to high court, and essentially what the Supreme Court said in about 45 pages of an opinion is that the state went too far. The state's examiner went too far, and in fact, the scientific basis upon which their examiner relied upon was not reliable enough. And the examiner could just come in and make these broad-based statements that those bullets came from that gun, which of course is what we have here. We have an examiner that's going to say there's sufficient agreement between the cartridge, the unspent cartridge that was collected from the crime scene in this case, and the firearm that was collected from Mr. Allen's home. And Mr. Tobin did testify in that case that the court noted his testimony and the information that he provided in the case. And I'm just looking here at my notes. Give me 1 second. I'll direct you to the area in the decision where that exists, because it's kind of a lengthy decision. It would be on, well, when you get there, I'll give you more. When you pull this case up at some point, so it'd be page 673, 674, would be the area where you're going to find the analysis as it relates to Mr. Tobin's opinion. But essentially, what the court said at the end of the day was, is that this process that is the foundation for firearm identification has been called into question, and there are legitimate concerns about the process from one coastline to the other in this country, and that the court was not comfortable because of those concerns in just allowing the state's expert to come in and make those broad, sweeping statements. The point of all this is, I'm trying to get to the point. I'm sorry. Is that the court didn't rely on his testimony in that decision, which I believe bolsters his credibility as it relates to this discipline. There is also this. Dr. Eric Warren, PhD from Memphis, Tennessee, will be likely testifying in this case, and you might note the state, in its own motion in limine, actually mentions Dr. Warren as having or as being a part of the same fraternity as the state's firearm examiner, Melissa Oberg. That fraternity being AFTE, the Federation of Firearms Identification. Frankly, all these acronyms start to get a little bit confusing at times. But Federation of Toolmark Examiners, right? Thank you. Sorry. Dr. Warren has been retained by the defense, and he's been deposed by the state more just recently. And the state has mentioned that, he and Mrs. Oberg are part of the same fraternity. That is true. And those two essentially believe in the same concepts. And so there's no reason why the defense should be able to bring in Mr. Tobin, who's not part of that organization, to critique that organization. And as it turns out, I would offer up, give me 1 second, I'm going to offer up an Exhibit E. Ms. Williams, mark this, please. Thank you. Dr. Warren's CV, and I would just specifically draw the court's attention to, 1 second here, page, you have a copy of this. Ms. Williams told me earlier when she made a copy for me, she had given one to you in advance, and so I think so he's trying to get, he can't remember which letters he's on to as far as exhibits. Let's see. Defendant's Exhibit E offered. The court, I haven't looked at it, it's just sitting here. Mr. Rossi. Okay, well, the problem is I highlighted some, the court. That's all right. Mr. Rossi, is that okay with the court? That's fine, I don't care. Mr. Rossi, but at the bottom of page 5, there's a reference here that he is a member of AFTE, Association of Firearms and Toolmark Examiners. And then maybe more importantly, at the top of page 6, the CV says he's serving on the board of directors and the editorial committee. And he previously served on the Electronic Resource Committee and chair of the Unpublished Research Subcommittee. I'm not really sure what that means, but what I do know is he's on the board of AFTE. He is one of the AFT board members. The court. Any objection to defendant's Exhibit E? Mr. Luttrell, no, Your Honor. The court. All right. Without objection, then E is admitted. Mr. Rossi, And so, in taking Mr. Warren's deposition, in fact, Mr. Luttrell was the one that took Mr. Warren's deposition, which occurred on October 3rd, 2024. There is an opportunity to engage Mr. Warren, who is on the board of AFTE, as to Mr. Tobin's credentials and his background and how those things are either helpful or not helpful as it relates to the discipline of firearms identification. And I would direct the court's attention, I'm going to mark as Exhibit F, a copy of Dr. Warren's deposition dated October 3rd, 2024, and this was ordered up again by the state. Mr. Luttrell and myself participated in that, along with Dr. Warren, obviously. Would offer that to the state, and the court. Any objection to Mr. Luttrell? Mr. Luttrell, no, Your Honor. The court, all right. I'll show without objection, F is admitted. Mr. Ozzie, specifically, Judge, as it states to Mr. Tobin's set of skill set and expertise, I would direct your attention to page 60 of that deposition. Let me know when the court's there. The court, Mr. Ozzie. So page 60, line 5, this is me asking the questions at this point. The question is, so is having a background in statistics helpful to understanding the discipline of firearm identification? Dr. Warren's answer, I would not say that statistics is more important than biology or chemistry or machining or engineering or things like that. It is certainly important, and I think will become more and more important as we move towards the shift in the way we testify and our testimony language becomes. And then I interrupted him. I'm trying to get through this, so I know the court can read through this, but moving down to line 15, he references the NIST, which is kind of a new technology that's on the forefront of firearm identification in terms of how they look at it. It's like microscopic images and 3D and things of that nature. But the point is, he acknowledges between line 5 and 12 that a background in statistics is important to understanding the firearms identification discipline. And if you note in Dr. Warren's, in Mr. Tobin's CV, and I'm looking for that notation, I had one of these that was highlighted, and now I'm not finding it. But he also had a background in statistics. Page 1 of his CV in the middle, there under additional courses and symposia. He had taken Statistics 1 and Statistics 2, both of Northern Virginia Community College. And I believe, page 2, professional affiliations. He's a member of the Statistical and Applied Mathematics Science Institute. He is steeped in the area of statistics as it relates to his education. And so that's one of the reasons why I was asking Dr. Warren about trying to inquire about whether or not that was important. Moving down, page 60, line 19. I asked him again, so you're referencing to that and suggesting that having a background in statistics might be more helpful might be helpful because things are trending in that direction in terms of courtroom testimony. His answer, yes, sir. Absolutely. That's the trend. There is an ongoing movement in this industry, firearms identification, to somehow codify some statistical approaches that matter and that have meaning and that make these conclusions that are being drawn in laboratories across the country meaningful. It's similar to what you would see in a DNA analysis, where they're starting to apply numbers and ratios and percentages to findings. And so that's kind of the background for what we're talking about. Give me 1 second. I then go on in page 61 and 62. I'm just summarizing. to talk to him about minimum qualifications that are required for these firearms identification technicians like Ms. Oberg. And what you'll find in there is that there is kind of a best practice that these individuals would at least have some kind of college degree in a hard science, like physics or chemistry or biology. But there is no minimum requirement in labs across this country. There's no minimum standard. So you can have a high school education and actually be a firearms examiner. I mean, it's not something that requires any specific education other than going through their own training course. So then moving one second. Page 63. I questioned him about, actually page 62, I'm sorry, line 13. My question is, have the critics of that group of people, and I'm talking about this critical community that we're talking about just before this in the depot, have the critics of the group of people, have these critics helped advance the tool mark discipline over the course of the past several years? His answer, yes, it certainly has, because I would actually say going all the way back to the early 2000s with a lady by the name of Dina Schwartz, who was a law professor at John Jay College. She was really one of the first big vocal proponents, or vocal critics, I should say, of our field. And that was actually a lot of that Mr. Nichols responded to. He's talking about Ronald Nichols, one of the experts that the state has referenced in their expert or in their witness list. Then he goes on to say they had a lot back and forth between the two of them. And in general, as frustrating as it may be from a practitioner standpoint to hear, looking at it, taking a step back and looking at it scientifically, it does improve the field anytime somebody from outside our profession that looks, with a bigger, broader foundation than us is able to provide insight that maybe we don't see when we're down in the weeds working evidence. So it certainly has advanced the field and continues to advance the field forward. The summary here is that he recognizes this critical community and that Mr. Tobin is a member, and that is a benefit to the field of firearm identification. My next question. So do you think that would be important moving forward and beyond today? That the body of people, those individuals that exist, to kind of continue to move this field in a more positive way forward? His answer, yes, sir. And he goes on to explain why publications can be helpful. Things like that, critique publications that critique their industry, that kind of thing. Page 63, line 19, question. And do you believe that Bill Tobin is at least one of the individuals that's part of the larger body or that larger community of critics? Answer, yeah. Generally, he is one, or he is of the critics that are out there right now. I would say he's not the most common person that I'm hearing about, but yeah, he's certainly always mentioned with the rest of the group of critics. Good God. Okay. Then I go on to question him on page 64 with tool mark or with firearms identification. Is it helpful for lab technicians to have an understanding of the mechanics involved with these tools, the chemical process involved, and the way these tools react when they touch other surfaces, i.e., metallurgy? And his answer is, so just for point of clarification, technicians, are we talking about like an IBIS technician? Are we talked about like and we go on, and I said, yeah, I'm talking about firearm examiners. And his answer is yes. So that is part of the reason for the 2-year, the lengthy training process. It's so that you can be taught and see firsthand and get hands-on experience with tools, with the way they mark their substrate and their work pieces. So he's clearly suggesting that having a background in metallurgy and understanding the way tools work with each other and these materials or these metals is highly important to the process of training firearm examiners. And then I just get right to the point with him. Page 65, line 4. I'm going to ask you a specific question. Would it be helpful to have an education background in the field of metallurgy in the course of being a firearm examiner? His answer, metallurgy could be very helpful, yes. And then he goes on to talk about hard sciences and those kinds of things. And I said, can you classify metallurgy as one of those hard sciences? And his answer, line 19, is yes, you could classify metallurgy as one of those. And then we go on page 66. I'm trying to move along, but all this is really important to educating the jury about Mr. Allen's defense. Page 66, line 10 through 17. There's a discussion there about PCAST. This court's probably heard about PCAST, the President's Council of Scientific Technicians or Advisors, basically. It's a group of people that the president has employed. They're a bunch of scientists, but essentially the task is to look at other disciplines and processes and sciences and be critical of them as to whether or not they actually do meet the minimum standard required by the scientific method. So it's kind of like the president's right-hand man. There are a bunch of his scientists. They basically say, we do believe in these processes or we don't. Well, PCAST, as Mr. Tobin would testify, has routinely and continuously acknowledged that the discipline of firearms identification is not a science. There would be testimony that is the position that PCAST has taken over the course of time. It's recognized as a discipline, and it's not recognized as a science because the discipline of firearm examination, does not meet the scientific process in many standards. So Mr. Tobin, of course, being very familiar with PCAST and those circumstances, again, is qualified to testify in a case like this. Then I go on, page 66, line 18. I'm asking Dr. Warren about whether or not there's a healthy dialogue that exists at this time as to whether or not the firearm identification business is a science. And he acknowledges to me that yes, there is a healthy dialogue going on, that still exists as we sit here today. In other words, that's still in dispute. So I'd ask the court to read page 66 and trying to move forward more on 67, line 8. My question is, so then you do agree that there's an ongoing debate between the two bodies of communities or people that as to whether or not this stuff should hold up in a courtroom. So now we're talking about something else, and I'm going to go to that in a minute. But the question is there a healthy debate about whether or not this stuff should end up in a courtroom? And his answer is, yes, sir, that is correct. This is a board member of the AFTE board members that's telling us this. Good God, how much more of this rambling is he going on? Quite a bit. Okay. I am going to take a short break. I need to use the restroom. And we're going to keep going because I really would like to finish up with this today. So we're going to go for another half an hour, 45 minutes, and read as much as we can. So with that being said, talk in the chat, and I will be back in just a minute. Okay, I am back. Let's continue on with his argument. Okay. He goes on to say, Mr. Tobin, being steeped in all of these things, it's our position as qualified to testify as it relates to the scientific principles of metallurgy and the principles that define or support the back or the discipline of firearms identification. I'll move on. Give me 1 second, please. I also mentioned the National Academy of Sciences in my response to the motion in limine, that in 2008 or 2009, that academy was critical of the discipline of firearms identification in that the laboratories, there's basically a recommendation from the National Academy of Sciences that the laboratories where all this work is done should not be government-based laboratories. They should be independent laboratories. And I think even you can look at the deposition of Dr. Warren, but I think even he acknowledged that that would be the best circumstances. That either that or he said he supports the recommendation, which is still not the case. These laboratories are run by law enforcement agencies, and there's been big concern globally that that's a problem. So I referenced that in my response. Mr. Tobin would essentially walk into the courtroom in Carroll County and he would explain his history, his educational history, and his work history, working in the FBI lab for 25 years in the tool mark business. And he would essentially explain to the jury that there is an underlying process that supports the discipline of firearms identification. And that is a process that I would argue that even Ms. Oberg is not intimately familiar with. She is a technician. She essentially has been trained to carry out that process, to execute the process. She is not part of the establishment of the process of tool mark identification. Earlier, what I heard, ironically, was that this gentleman who generates composites that law enforcement authorities use to seek suspects, they issue those publicly. They ask for people to look at those things, and they said, if you see somebody that looks like, or if this helps generate a thought that where somebody might be a suspect in this case, tell us about it, because we might investigate them. What I heard was a discipline, and it was a tool. If it was a tool to help law enforcement, what you will hear from Mr. Tobin is not that this is all junk science. You will hear him testify that firearms identification is also a tool that is used by laboratories across this country. The problem is whether or not the conclusions drawn from those examinations are reliable in courtrooms like this, and should they be used to assist juries in determining guilt or innocence. That's where the battle lines are in the industry. Mr. Tobin is on the one side of the battle line and has been for a long time. The state's examiner, I presume, is on the other side, although I don't know that she's even been questioned about that. In particular, I would also note to the court she doesn't even work for the state police anymore. She's working in private industry at a medical device company or something at this point. I'm not really sure where in this, but Dr. Warren is still in the industry. He supports Mr. Tobin's credentials, believes that Mr. Tobin's work in this field has been helpful in advancing the industry, and so would ask the court to take those things into consideration. I do think that the concept of understanding the process which generates a result in a laboratory setting is relevant to understanding the meaning or the result of the final product. And that is to say, for jurors to understand how a woman in this case, can come in here, Ms. Oberg herself, and say, I looked at, did some microscopic images of cartridges and firearm and these, all these tools, and I have drew a conclusion that the cartridge was cycled by that firearm. I think it's only fair that the jurors would have some information that would help them understand the process that supports, or the foundation that supports that process. And I'll leave you with these examples. I'm just thinking practical examples in our everyday circumstances. The first one that came to mind, I happen to do a lot of DUI law, is the certified chemical testing machine. And anybody that's ever presided over a certified chemical test case or cases on a routine basis knows that if there's a trial in those cases, one of the things you might hear is an expert testify about what's going on inside that machine that helps generate a number, whether it's 0.10, 0.15, or 0.20 or 0.25. Those are just numbers generated by a computer. What you really want to know is what happens when someone blows into that thing and the breath starts moving through all the tubes and filters. That's important to know. It's fair that a jury knows that. And there's no difference between the circumstances, really, and this circumstance. The second thing that came to mind as I was driving this morning are canine searches. When an officer pulls a dog out of a police car and starts running them around a car, and the dog sits, and the police officer now has the right to move into that vehicle, to essentially search that vehicle and cross a privacy boundary, a constitutional boundary, could even be a house. I think it's only fair. And it happens in courtrooms across this country that people get to hear how these dogs are trained, where they come from, how credible are the kennels, what are the dogs trained to do? Are they trained to detect bombs? Are they trained to detect drugs? Those kinds of things. It's helpful. The idea that you would understand a process tends to prove or disprove the legitimacy of the process. And that's why it's relevant. The only other examples I could think of, polygraph exams did kind of come to mind. Another one, as I was listening to Mr. Plants, Mr. Plants testified today. He was talking about how long the interview process takes before he even puts pen to paper. It's exactly like a polygraph exam, right? The polygraph examiner sits there for an hour, a good examiner, for a couple of hours, and questions the witness or whoever's being examined in that case before the exams even starts. It's the most important part of the exam. And I think that to the extent that somebody wants to understand that process, in most cases, in those circumstances, a judge, because we're not introducing this before the juries, you'd want to know the process because that's the most important part of it. So those are some thoughts. Radar guns come to mind. I know you deal with those from time to time. Nobody ever has the money to really bring an expert in and talk about what goes on inside that little gun when you get your 55 in a 45 speeding ticket. But it has happened. There's records in courtrooms where that's happened. I think all these things are good analogies to say Mr. Tobin's credentials mattered in this case. And I will leave you with this. Mr. Luttrell, I believe it was, in his motion in limine, cites as authority, he didn't talk about it today, but he cites in his motion the case of State of Indiana versus Cade and Smith. It's a trial court level case out of Marion County, one Mr. Baldwin actually was involved in, just coincidentally. 49D 20-2112-MR-36708. He cites that court's ruling as authority for you to deny Mr. Allen the right to bring Mr. Tobin into the courtroom in Carroll County. And the ruling says the order from January 29, 2024, earlier this year, the state moved in a motion of limine in paragraph 5 to exclude the testimony of defendant's witness, William Tobin. The court heard argument in January 26, 2024. At a pretrial hearing, defendant witness has not tested or reviewed any of the evidence in this cause. The defendant will have the opportunity to cross-examine the state's witness to present his defense at the shortcomings of firearms examination. The court now grants the state's motion in limine, paragraph 5. That's the authority that you were offered in the motion. A 1, 2, 3, 4, 5, 6-line order from the trial court in Marion County. Well, if you want to do that, that's fine. I'm going to offer the court up People versus State, or People of the State of Illinois versus Ricky Winfield, Circuit Court of Cook County, Criminal Division, 15 CR 14066-01. This is my copy. I've got the court a copy. Mark this, please, for me. Thank you. Defendant's Exhibit G. I'd offer this up to the court. The court. Mr. Luttrell, any objection? Mr. Luttrell, I have no objection to you reading the extensive opinion by the judge in Cook County, Illinois. The court. All right. I'll show G is admitted without objection. Mr. Rozzi, thank you. Extensive and well thought out. Mr. Luttrell, I object to well thought out. I don't endorse that, but it's very long. Mr. Rozzi, you know it's the court. Okay. Mr. Luttrell, I apologize for interrupting you, Mr. Rozzi. Fine, Jim, no problem. Page 35, I'm going to try to get the court to the heart of the matter. Page 35, the top, same argument in Winfield, basically. Did bullets come from a gun? That kind of thing. It's all pretty much the same playing field with these cases. In part, the court says, the court found that the testimony, declarations, and corresponding defense exhibits of the following defense expert, credible and helpful in establishing firearms identification evidence, is no longer widely accepted within the meaning of Fry, including, but not limited to, and it could go on and on. I'm going to get to Fry in a second. Section D, or paragraph D, also relevant. The defense criticisms of fire identification evidence were helpful, highly persuasive, and credible in this court's finding that firearms identification evidence is nothing more than a mere hunch, as that term has come to be known as under Illinois jurisprudence. Then he goes into paragraph E to talk about general acceptability, which is one of the scientific processes that Mr. Tobin would testify about, and basically indicates that they don't indicate, the judge here states that there are concerns about whether or not it's generally accepted in the scientific community. And then page 36, you can read this, Judge, in your own time. Page 35 and 36 are really where you need to see the relevant portions of that as it relates to what Mr. Tobin would be contributing to this case. That too is a trial court opinion. I'm not going to sit here and suggest that somehow it's primary authority in a case like this, but it certainly is much more meaningful than what went on in Caden Smith's case. No disrespect, Mr. Baldwin, down in Indianapolis, where you got a 6-line order. This is a thought-out opinion that contains arguments on both sides, and that's what we're pointing out here. It's not what's true. That's not really the point. It's not who's right, because nobody's really right. We'll never probably know, but it's about what those people should hear about one of the most important pieces of evidence in this case. There's an ongoing debate in the world about the reliability of the methodology used by Ms. Oberg in her firearms identification conclusions. And we're asking the court to allow us to tell the jury and explain to them what it is that is, explain to them the process that's employed, which helps her come to her conclusions. And that's why we think it's relevant. Thank you. The court. Mr. Luttrell, anything else? Mr. Luttrell. Yes, Your Honor. The Cook County Trial Court opinion that you have before you, as well as the Maryland Supreme Court decision, at least two things about those. Number one, they're outliers when you look around the country in terms of where the majority of appellate courts are today across the country. It's not with the state of Maryland, and it's not with the judge in Cook County, Illinois. It's also noteworthy about those two cases. I believe Mr. Tobin was involved. Was he involved in the Cook County case? I think Mr. Rozzi. I don't think so. Mr. Luttrell. I believe, Mr. Rozzi. No, I don't think so. Mr. Luttrell. He may have testified. He may not have. But those were Daubert or Fry hearings in those courts where those testimonies took place. Mr. Tobin testified in the Maryland court, not in front of a jury, but in what they call a Fry-Reed hearing, which is Maryland's version of 702. That's very different than bringing someone in to talk in front of a jury. Statistics. I don't believe that statistics, certainly the statistics that Mr. Tobin has some areas of study in, is going to be relevant in this case. Why the reference to high school education? There's no accreditation standards around the country require college education in a science to be employed as a forensic scientist. Mr. Warren, in his deposition, may have acknowledged that some critiques have helped the industry, but that's a far cry from him endorsing Mr. Tobin and Mr. Tobin's view on firearms, which it's clear from the deposition that he does not endorse. He did not endorse Mr. Tobin's specific efforts or testimony or works in this area. He only said a group of critics generally have helped the industry improve. That is not an endorsement that the jury ought to hear from this individual. The fact that there may be a healthy debate, or what Mr. Rozzi called a healthy debate, and Mr. Warren, Dr. Warren, acknowledged is going on, has nothing to do with the role of a jury and the role of an expert witness in this particular case. And I think the issue of the difference between looking at a trial court's decision, I only reference the Caden Smith case as an example of a very recent ruling involving him appealing before a jury. The Cook County case, he was not appearing before the jury. He was appearing, if he did appear in that case, that's a threshold issue. It's a very different situation than having his level of confusion enter into the courtroom in front of the jury. Thank you. The court. All right. Well, clearly I need to take this under advisement to review all the exhibits and the depositions and the order and the CVs. So I will take it under advisement and issue a ruling in due course. Mr. Rozzi, very good, Judge. The court. Is that the conclusion? I don't have any other written motions. Before we recess then and travel down to Carroll County, is there anything else from the state? Mr. McClelland. Judge, I do have one topic and I'm not sure how to address it, and so I didn't put it in the motion. But from the closed hearing that we had a couple weeks ago, it was my understanding that the parties would submit a kind of narrowed exhibit lists to each other, to narrow those exhibits to exhibits that we knew were definitely going to come in. So we would focus on those exhibits. Because as the court can imagine, hundreds and hundreds of exhibits. The court. So she's agreeing that she remembers this conversation. And we had both agreed on October 1st as being that date, and that's fine. We've done that. The defense was kind enough to attach their exhibit or their witness list with their exhibit list as well, and that's fine. But they've listed several new witnesses that weren't on any prior witness list. And if it was a foundational witness or a witness that observed something in the case, I wouldn't care all that much. But a lot of the witnesses, it looks like, are expert witnesses or are going to testify to something very specific in regards to the case. And so on October 3rd, I sent an email to Mr. Rossi asking him, hey, are these new witnesses? What are they going to testify to? A couple of these witnesses, I was able to look off the internet, look them up on the internet. They look like experts in the digital field. I got an email back from Mr. Rossi on October 4th, basically saying, well, I'll just be specific. Neil Broom and Stacey Eldridge. Knowledge of data contained on phone extraction of LG's phone for Neil Broom. Stacey Eldridge, knowledge of data contained on phone extraction from August 2024. That's all I got. The email goes on to say, we intend to deliver a thumb drive to your office later that day with exhibits that we intend to introduce. I thought perhaps there may be reports on there, CVs on that thumb drive, something for these people. We didn't get the thumb drive until the next week. The only thing on the thumb drive were the CVs for those two people specifically. I attempted to call those two people on October 7th. Neil Broom refused to talk to me at all. I just had 3 simple questions for them. When did you get contacted by the defense? What evidence did you review? And what are you going to testify about? In an attempt to gain information about what they're going to testify about, Neil Broom wouldn't answer any of my questions. Said he had a responsibility to the client to keep all that privileged. Stacey Eldridge did answer some of my questions, but when I asked her about what she was going to testify to, she said, I can't tell you. This is yet to be determined. There are some other witnesses as well, like a former prosecutor, Robert Ives. There's several other, James Chadwell, Richard Everett. The only explanation we got for those, for Rob Ives, he publicly commented on the aspects of the investigation. And then for these other, looks like prior defendants in Carroll County, the explanation was motorcycle gang member in Delphi, morning of February 13th for a pretrial hearing. Again, Judge, my problem is trial by surprise. We're going into the trial, and I appreciate I can depose all these people, and I appreciate that. But we don't have time to do that at this point. And so specifically, with the experts that are going to testify, the state would request some kind of report, summary, allow me to talk to them on the phone briefly with defense counsel present, something to give me some information about what they're going to testify to. I'm shocked that Neil Broom or Stacey Eldridge, if they're going to testify about phone extraction done on LG's phone or digital data, they don't have some kind of report to go with that. And the state's concern is we're going to have an expert up there testifying, and I have no idea what the extent of their testimony is going to be. And at least one of these experts, as of October 7th, didn't know the extent either. And so I guess I just want to bring it to the court's attention that without those things, the state's going to object to them being called as witnesses as late disclosure, and then no disclosure at all in some cases. And so I'm not really sure how to address it, Judge, but that's a concern the state at this point. The court. Mr. Razi? Mr. Razi, thank you, Judge. A couple things. First of all, looking back at the court's order regarding the exhibits, the circumstances with exhibits, the order itself actually only required the parties to exchange exhibit lists as of, I'm trying to get my head straight in terms of days, I think October 1st. I need to look at that order. We actually tendered a full-blown exhibit, updated witness list, and, as Mr. McClelland mentioned, a hard drive to them with as many of the exhibits that we could get on there and some of them were duplicated. They were things that the state already had, but there were things that we put in there as a courtesy, even though we weren't required to. We provided all that to the state. As it relates to these names that they're throwing around that Mr. McClelland's talking about, Broom and Eldridge, they are people that we have sought out to assist us with information regarding the digital data. As I mentioned to him in the email, because of new Celebrate phone dumps that the state gave to us, it looks like, I think it was August 23rd of 2024. So I even got a discovery dump yesterday, I think I did, from Mr. Mullen, in fact. I mean, just to give you some idea of how ongoing this is. So we got a discovery dump in August of 2024, late August, that contained information that needed to be reviewed by somebody. So we were seeking these people's assistance in that regard. And so I understand that they're like, hey, it would be kind of nice to know what's going on with these people. Well, it would be kind of nice to have this evidence before August 23rd of 2024. So it kind of cuts both ways. I don't think there's any bad faith here. We're talking with our people. They're talking with their people. We've done a ton of discovery in terms of depositions. They've ordered up very few. And that's their choice. That's their approach to preparing their case. But at the end of the day, we offered the names of those people up on October 1st, and they have not asked to depose those individuals. I'm not really opposed, as just a matter of professional decorum or courtesy, I should say, to allowing some contact between the state and these people in the next week or so. If we can figure that out, or, some kind of communication so that they have some idea what these people are going to testify to. But there are no written summaries. We haven't asked for those. They don't exist. They're not holding something that we're not giving to them. It's just a matter of this discovery coming in and hitting us almost weekly and just trying to react to that. And so that's the landscape on which all this is occurring. I think that we're willing to have some constructive conversations about how they can get access to that. Frankly, I have. I mean, other than emails, I'm not taking shots at Mr. McClelland. We had a nice conversation in his office a week or so ago about many things, but he hasn't. Other than that email, there hasn't really been any discussion about this in any detail up until today. Can I say one other thing that's just slightly off point here, just because it's a procedural matter? The court. Well, can we resolve this first, Mr. Razi? Yeah, sure. The court. I mean, are these witnesses going to testify? Neil Broom and Stacy Edridge? Mr. Razi, Ms. Edridge will be testifying, and the court. So, Mr. Razi, possibly. Mr. Broom, on rebuttal maybe. Miss Auger, maybe. Mr. Baldwin, maybe. Goodness gracious. The court, you need to provide then to the state the substance of their testimony. Mr. Razi, but there are no reports. That's what the rule requires us to offer up. The court, the substance of what you expect them to testify to. Ms. Diener, Judge, I would need that also with Stuart Gracian. We've asked for a report. They said they had none. We got no other response. The court, okay, so there are three now: Neil Broom, Stacy Eldridge, and Stuart Gracian that are going to be called by the defendant, and you have not provided to the state the substance of their testimony. Mr. Razi, no, because there are no reports. Mr. Gracian never generated a report. Mr. Broom never generated a report. Ms. Eldridge never generated a report. They've been aware of Mr. Gracian since the first witness list was filed back in April of 2024, or even March maybe, going back in time, and they've not asked. They've taken 2 depositions in this case that I'm aware of and that I've been a part of since we've started. And so those people have been the states. They've been on the state's desk. Their names have been on their desks for months. The court. So you have no intention then of providing any information to the state of Indiana about these 3 witnesses and the substance of their testimony. Mr. Razi, I mean, as a courtesy, I don't have a problem with, I don't know, maybe, I guess in some form of an email or something, just identifying, hey, this is what we generally expect this person to testify about. But I don't think we have any obligation to provide any details in terms of their testimony. That's what the discovery process is for. And this isn't discovery. This is walking into a courtroom in a pretrial hearing. Do any of you find this odd that they did not want to tell them what they were going to testify about? Mr. McClellan, Judge, I'm not asking for specific details on what they're going to ask the witnesses. I don't believe in trial by surprise. That's my problem, Judge. And I have no idea what at least Neil Broom, in terms of Neil Broom and Stacy Eldridge, I know that knowledge of data of contained on phone extractions of LG's phone. That's the explanation I got from Neil Broom. The explanation I got from Stacy Eldridge is knowledge of data contained on phone extractions from August of 2024, which is Christopher Cecil's phone extraction. That's the only information I have. And Neil won't talk. Mr. Broom won't talk to me. And Ms. Eldridge says, I don't know what the scope of my testimony is going to be. I don't need specific questions they're going to ask them. I just need the topics that they're going to cover and what they're going to talk about. I'm really surprised there's no report if they're going to talk about the digital data. Typically, there's reports with those kinds of things. So I just want some explanation of what the scope of their testimony so I can prepare for cross-examination. The other witnesses, the state may object to relevance on those. Robert Ives, the former prosecutor. These are motorcycle gang members listed. I guess I'm just unclear about what those are going to test. People are going to testify to. And I appreciate we can do depositions. The problem is we don't have time. Not now. And so at least for those witnesses that were added on October 1st, that's the state's issue, Judge. at least from my perspective. Ms. Diener also testified about Mr. Gracian. We've never really had any kind of explanation of what he's going to testify to. The court. So are you going to, Mr. Razi, provide your provide your witnesses with your authority to communicate to the state of Indiana? Mr. Razi, yeah, I don't have a problem. The court, okay. Mr. Razi, I have no problem with him talking to these people. The court, okay. Then advise those individuals to expect at least a phone call or written communication from the state. Mr. Razi, yeah, sure. The court, as to the content of their testimony. Mr. McLeland, thank you, Judge. Nothing else from the state's perspective that I can think of off the top of my head, Judge. The court, okay. Anything from the defendant? Mr. Razi, Judge, I had one other procedural matter. I just need to make sure we weren't overlooking all the pleadings. We all kind of talked about, I think, off the record yesterday about the DOC transports. The court, yeah. Mr. Razi, do you want to talk about that off the record or the court? Yeah, we can. Mr. Razi, and try to figure out how to deal with the logistics of all that. That's really the issue. The court. Yeah, they need 24 hours notice, minimum of 24 hours notice, and I need to get some kind of timeline, I guess, from you as to when you expect they would be called to testify. Mr. Razi, yeah, I agree. It's kind of difficult because we also didn't know who, based on some of the rulings today, or that you're going to issue tomorrow, how that's going to impact the witnesses. Maybe if we're okay, we can have a little powwow off the record to try to. The court, okay. Mr. Razi, get. The court, that's fine. Mr. Razi, try to figure that out. Mr. McClellan, thank you, Judge. Mr. Razi, okay, thank you. Ms. Diener, thank you. Ms. Auger, Your Honor, one more quick issue? No? The court, go ahead. Ms. Auger, the order incorporating, allowing the defense to incorporate the previous provided materials on the motion of limine included issue, subject matter concerning Odinism and other topic, which is currently escaping me. It did not include the information regarding ritualistic killings or the balance of the court's order in limine. And so our request is, can we go ahead and incorporate those, or do we need to bring Ms. Perlmutter back to the court? Oh no. Ms. Auger, testify about ritualistic killings. Mr. Baldwin, that was my fault, Judge. I don't think. The court, no. Mr. Baldwin, if you just signed my order, I don't think I included those in there. I apologize. Mr. McClellan, no objection from the state. The court, I grant the motion to incorporate all of the evidence. Ms. Auger, okay, the court, so that there would not need to have a separate offer to prove covering hours or days of testimony. So whatever you presented at the hearings, July 31st to August 1st, that covered the third-party suspects and the ritualistic allegations and the allegations about Odin and Norse paganism, all of that is included in the offer to prove. Ms. Auger, thank you. The court, so that you would not have to recall all of those people. Ms. Auger, thank you. The court, okay. Mr. McClellan, Thank you, Judge. The court. Thank you. Jody, you can go off the record. Off record at 11:59 a.m. So that was a lot that they went through in that half a day of a hearing that was supposed to be the third day of jury selection. Now, in the next live, this is when trial starts. So I believe we're going to go through all the instruction and the opening statements. And I will make a different live stream for that one. But at least we've got done the hearing. We had to do it in 3 parts. This one took 2 hours versus the hour and 20 minutes that the first 2 were. If you haven't heard all of that, please go back and take a listen. It does explain some things. And we know that the first day of trial, that Judge Gull still had to make some rulings on some motions that the defense and the prosecution had. Any questions from anyone? Yes, Chris, the trial transcripts are here. Silas says, you're doing a great job. Thank you. You're welcome. Okay. What? I don't even know where my phone went. I have no idea where anything is. It's 2 p.m. here, which is 2:02 p.m. here. So it's 3:03 p.m. in Eastern time. So we're going to get around dinner time here. Let's take a couple hour break and I'll create a new thumbnail and everything for the next live. We'll probably do that at about let's see, 5 o'clock. My time is 6 o'clock. Your time. Is everybody usually done with dinner about that time? Or are they still eating dinner? Let's do it like a 2.5 hour break. And well, let's do it 5 o'clock my time, which is 6 o'clock Eastern. We'll come back and we'll read the instructions and the opening statements. And then we'll go from there. All right, everyone. I'll see you in a little while. Bye.